Thank you, Jim, and thank you, Barbara, for putting this on and inviting me tonight. This is our firm. We are lawyers that practice in these areas, and we're a focused firm, call it a boutique firm, specializing in estate planning, business planning, elder law, and services to clients and their families to help prepare for the future. And in fact, today we're going to take a look at the future and what it's going to hold and what it might hold for each and one of us. We're going to look at the election, the aftermath of that, the importance of estate planning, regardless of the election, and the core four documents that every one of us needs. We're going to talk about trusts and trust planning, asset protection planning, especially for long-term care, and planning for IRAs, a little bit of charitable planning in there with that, and then how to get your plans started. It's great to talk about estate planning. It's better if you get a plan done and getting to that place where you have peace of mind, which we'll talk about at the end. And this is our red wave slide. The red wave that was supposed to hit in 2022 really crashed on shore in 2024. And we have the presidential election with President Trump, the Senate and House and Supreme Court all being right-leaning and Republican. And so what does that portend for the future? We're going to talk a little bit about some of the legislative proposals. I'm not going to get too deeply into the income tax proposals, but I will talk about some of the estate and gift and generation skipping tax. But this slide really puts in perspective for me where we are as a country and what is realistically possible in terms of legislation and legislative priorities. The debt of $36 trillion has been growing, and the number at the bottom is the number that to me becomes the most frightening, and that is the interest payment on the debt. $1.16 trillion in 2024. And if you look at the deficit for 24, it is 1.9 trillion. So how much does that interest payment add to the deficit? And just the interest on the debt has become the third largest federal budget item. Medicare, Social Security, and interest payments on the debt. Interest is higher than our defense budget. And it's something, if we cut taxes and cut all of the things that are being talked about, we will have a debt that will subsume our annual budget and would make discretionary spending very, very difficult going into the future. So will taxes stay very low? Will tax cuts be reimposed? We'll talk a little bit about that. But in the long run, the only way that we're going to get back to a normalcy in our federal budget is to raise taxes and cut spending, two things that nobody going into federal government wants to talk about. So let's back up a few steps. That's a lot to think about, and it's a lot that keeps me awake at night. But what I feel good about is getting a good plan in place and having the people in place that will make decisions for you during those times that you can't make them for yourself. So identifying your planning goals, who are the right people to make decisions, financial, healthcare, and other estate and legal planning decisions for you, getting the documents done that empower those individuals to make good decisions for you. How do we make sure that our plan provides for us during our retirement, throughout our lifetime, that we're able to protect and preserve our assets and our income, be able to live the lifestyle to which we hope we can become accustomed, or as I like to say, the lifestyle to which my children are accustomed. So we want to make sure that we keep planning in the forefront of our minds and have a discipline in our financial plan, our tax plan, our legal plan, and each of those works together to protect, preserve income, assets, and hopefully, if the plan is successful, I have a lot of clients that say my ultimate plan is to spend my last dollar the day before I die. I haven't found anyone that's been able to carry that out yet. And if you're good at saving during your lifetime, odds are you'll keep saving during your retirement. So the legacy that we leave to our children, our grandchildren, our charities, that legacy becomes a good part of our estate planning. So let's start with the basics. Everyone should have these 4 documents. We refer to them as the core 4. And the core 4 include 2 documents that operate during our lifetime and 2 documents that operate upon death. And the 2 documents during lifetime, we call them advanced directives. One is a power of attorney. The other is a healthcare proxy. Those put decision makers in place for financial and healthcare decisions for us during our lifetime, but upon death, they fade and no longer have effect. Once you pass, then a will has to become part of the plan, and you have to have a will to dispose of assets, but the will isn't a good place to dispose of your body because the will doesn't have any impact until it goes through probate, and that usually takes weeks, if not months, if not some cases years. So there's a new document in New York, relatively speaking, called the Disposition of Remains Appointment. And let's talk about the 4. Power of attorney, again, a financial document, and you can appoint a single agent for this document. You can have co-agents. You can have co-agents acting independently or separately. You can have your co-agents acting jointly. So you get a bit of a system of checks and balances if you want them to act together on all decision-making. But that means they have to sign things together at the bank or at the closing or wherever the business is being transacted on your behalf. In most cases, if it's a married couple and they have children, the spouse will appoint each other, and then 1, 2, 3 kids would be the alternates. And again, co-agents can be structured into your planning. We want to make sure that we have certain powers in the power of attorney. We want to make sure that we have gifting authority, because if we want our agent to be able to do more estate planning, if you haven't done the full extent of asset protection planning or tax planning, and you want your agent to be able to carry out those functions on your behalf, then you have to have those specific provisions tailored into your document. And we do that for virtually all of our clients. Your agent is someone who you're going to appoint. They're going to be a trusted individual, and they're going to sign an oath that they will follow your pre-existing plan, not go outside the bounds of what your intent is, and in all cases, keep your money safe on your behalf, use it for you, pay your bills. You can have a durable power of attorney. That's what almost all powers of attorney are. That simply means that its durability lasts beyond your incapacity. You can also have a springing power of attorney that says, this power of attorney I'm going to sign, but it doesn't have any effect until I'm determined to be incapacitated. And it springs into life, typically upon a physician's affidavit that you are no longer capable of managing your own financial affairs. If you don't have the healthcare proxy and power of attorney, you're going to run into issues. The living will healthcare proxy document is the corollary to the power of attorney, and that puts in place a decision maker, in this case, one individual at a time. We always layer in alternates. So you have a well-done healthcare proxy. You name the people that you trust to make healthcare decisions on your behalf. And then in the living will portion of the document, we do this all in one document, you will create a plan for end-of-life decision-making. So this typically covers things like artificial respiration, nutrition, hydration. Do you want those things in circumstances where you're in a condition that's terminal and you don't have a quality of life that you believe is sustainable? So you want to give them the ability and authority to make that decision on your behalf. Our firm does a lot of work in this area. One of my partners, Peter Strauss, is a pioneer. He's been doing this longer than I have, and he wrote a book, and we have adopted that as a guide. So if you'd like to get more on healthcare decision-making in New York State, including discussion of the medical order for life-sustaining treatment, or MOLST form, a do not resuscitate order, how does that fit in? That guide is available to you at the link there, pierolaw.com, on our resources page. All right, so those documents are while we're alive. Upon death, the disposition of remains appointment kicks in, and we have an agent who's going to come in, literally claim the body from the hospital or wherever. If you died at home, this is the gory details of a disposition of remains appointment. They're going to arrange with the funeral director for your embalming, cremation, green burial, whatever your intentions are. Do you want to have a religious service? Do you want to have a funeral? Calling hours, all things that people think about. The trends have been towards cremation and informal get-togethers. We call them celebrations of life, as opposed to the formal calling hours at the funeral home. And that's something that, just my observation, having done thousands of these now, that has been the trend line, is away from formal burial, away from the calling hours, and more towards an informal type of arrangement. So this document, again, one agent at a time, always appoint alternates because you never know if that one agent is going to be available. And that takes care of your body upon death. Your property upon death goes through a will. And wills are documents that appoint an executor. That's the fiduciary, the person you trust to take your assets, go through your home, go through your personal possessions. Digital assets are part of estate administration now. You have passwords, codes, all the things that need to be thought about and contemplated in a will. That executor is going to go through your home, collect those assets, make distributions of tangible assets, collect your financial assets, go through all of this, real estate. The only way that that executor gets authority to do the things I just mentioned is from a judge. Every will has to go through probate. Every will has to go through the court, and a court issues a decree admitting the will to probate. The will goes into the court system, and the judge issues a certificate. It's called letters testamentary. And if you've been an executor of an estate, you're shaking your head right now. Yeah, that's what I had to go through the court process to get. Once you get letters testamentary, and it could take days or weeks, it could take months, depending upon circumstances, then you can go about the business of collecting assets, paying bills, paying the funeral bill, all of the things, credit card debts, making sure all of those get satisfied, and then making sure the assets get distributed to the appropriate people. It is possible to create a trust under a will. It's called a testamentary trust. And if you, for example, have a child with special needs, just one type of the trust that we're going to talk about, in your will, you want to make sure that you have protected that child with a special needs trust. And for that, you would appoint a trustee to manage the assets for your disabled child. And that would require also then letters of trusteeship for the court. Every will, by definition, goes to probate court. A lot of people come in and say, oh, I have a will. I've avoided all of that. I've avoided the probate court. Your will is why probate is there. It's there to take the will and put it through the paces of probate, where the judge is going to review it, scrutinize it, issue the letters. You then have to marshal all the assets through the estate, file an inventory, file an accounting, file papers, releases, waivers with the court. That is the probate process. So those are the basics of a will. And when you have the core four, you have a power of attorney, healthcare proxy, disposition of remains appointment, and a well-drafted will, you have all the basics buttoned up. Now, the people that have died without a will, we like to think about celebrities, people that weren't as smart as you if you have a will. And, you know, everybody from Picasso to Jimi Hendrix to Michael Jackson, Prince, these are estates that went through the courts without a will, and that's called an intestate proceeding. One person who we thought was in intestacy was Aretha Franklin, but as it turns out, as they were cleaning out her house, they found not one, not two, but three wills in her own handwriting, one stuffed in her couch, one in a cabinet, and they had to litigate that. So you want to make sure you do this right and do it. We keep wills in a vault so they don't get tampered with. They're inviolate. If a will does have to go to court, you want to make sure that it's going to go cleanly and that the judge is going to have no problem admitting it to probate. So when we don't plan thoroughly, we end up in court. And that could be not having the right power of attorney, not having the right healthcare proxy, not having a well-drafted trust document. All of those situations would put us either in guardianship court during our lifetime, if we don't have planning, or the probate court. Our firm does a lot of court work. We make money in court. That's where we have a monopoly. And my partner, Aaron Connor, does a lot of litigation in addition to just the routine administrations. So that is not where you want to be. You don't want to be the subject of a guardianship proceeding. It's not where you want your family to be, going through a guardianship or having to go through a court process where there is potential for conflict and delay and additional costs that are going to drain your estate. And so the will is one way to plan, but we think a better way to plan for many clients is to enact a trust. A trust is a living, breathing document that you create today. You transfer assets in, and that trust then can manage your assets. It can distribute and take care of yourself as a beneficiary and other beneficiaries. And upon your death, that trust can then make distributions to individuals without the necessity of a court proceeding. So you can avoid probate through the use of a living trust. And the trust both works for you during lifetime, similar to a power of attorney, but with much more control. It transcends your death, works upon your death, and after to make sure that your beneficiaries are taken care of without that court proceeding. You make sure you have good trustees, and this is where you select your fiduciaries, and the trustees will step in and work in your stead. Everything is private in a trust administration, unlike probate, which is public, and we transfer the assets in now. So consequently, a trust plan is a bit of a heavier lift than a will. A will is just a document you create today that doesn't have any impact or any effect until you die, and then your named executor hires the law firm to go through the probate process. That's when the will gets its authority. A trust gets its authority the day you sign it. It is a contract between and among a grantor, which is you, trustee, which may be you, and beneficiaries, which could also be you. So trusts are a solution in estate planning for a lot of different factual situations. We call it the Swiss Army knife of estate planning, and we have revocable trusts. We have irrevocable trusts, living trusts, which I just mentioned, testamentary trusts, I mentioned earlier, go through the will. We do trusts for asset protection, for tax planning, hold life insurance policies, for special needs children, and a trust I'm going to talk about to protect all of our children from a variety of different risks that they have that we can protect them from very, very efficiently in our own documents. The most basic type of trust is a revocable living trust. Your assets get organized, retitled into the name of your trust. It provides for management during your lifetime so that you can have all of your affairs managed through the trust. And in the beginning of the trust, you are the manager. So in a revocable living trust, you can be your own trustee. Spouses can have joint trusts and be co-trustees. Depending upon situation, you can have multiple trustees. But in most cases, the grantor or grantors serve as their own trustee, manage the trust assets, use those assets for their own lifetimes, and the trust becomes extremely valuable in two circumstances. One is if you become incapacitated and you're unable to manage your own finances, a trust gives you the ability to write a contract where you are the original trustee, you're the grantor, you're the beneficiary. But if you're deemed to be incapacitated, usually by a physician, then your successor trustee will step in and simply step into your shoes to manage that trust for your benefit under the terms that you define within the trust agreement. And that's the biggest difference between a power of attorney and a trust during lifetime You get to tailor the script and write the script for the agent, the trustee, to follow your instructions. Upon your death, that trust does not have to go back to court, does not have to go through the probate process. It can be administered by your successor trustee, and the beneficiaries that you leave that legacy to will be able to receive their inheritance without any delay from the probate process. So great lifetime management features, great death time probate avoidance features, and you can create those downstream trusts without the necessity of probate and have them free of the probate court. The one downside to a revocable living trust plan is if you want to protect assets for yourself, the revocable trust doesn't do it. It's still yours. These are still your assets. This is a schematic of the revocable trust plan. You're the grantor. You hand off your assets at number one into the trust. You're the trustee. So your bank accounts, brokerage accounts, real estate, assets get retitled in trust name. You manage them. Your name's on them. You're the trustee. But if something happens to you, you have a successor that just steps in behind you. You get to use all of the assets in the trust. That's number two, income and principal. And that trust operates for you during your lifetime. If you're incapacitated with a successor trustee, upon your death, and number three, it passes down to your beneficiaries, your family members, your spouse, your children. And it does so in a way that is extremely efficient, secure, and cost effective. You'll see over to the right side of the screen that retirement accounts do not get retitled. When you have an IRA or 401k and you do use a trust, you don't retitle it. What we do is we redesignate the beneficiary. So we don't change the ownership of the retirement account during your lifetime. We change it upon your death. And we make the trust the beneficiary so that you have the ability to tie it back together again. So a very, very powerful but simple plan, an elegant plan to put your estate in order, to have it managed during your lifetime, to have it go to your beneficiaries upon your death without court intervention, and to have the ability to then tailor the beneficiaries. And this is where we get to the point where we look at how to best leave our children and grandchildren and other beneficiaries their inheritance. If we want to leave it outright, that's always an option. You can simply say that when I pass, my trust ends and my assets go to my beneficiaries. My house might get sold, my stocks and bonds would get distributed, my bank accounts, life insurance, all of those things run through the trust and get to the beneficiaries, and you would create shares. If you're leaving money to charity, you can do that through the trust as well. But what if we want to take another step? And this is where the future for me becomes even more compelling, to look at how you're going to leave that inheritance to your kids. We have so many different risks that people fall prey to today. Divorce, over 50%. Lawsuits, scams, people trying to get at assets, especially when people get later in life or have a disability. They can be preyed upon by people who are unscrupulous. We can put together a trust and have our child be their own trustee. They can manage the trust for their own benefit. They can choose who the ultimate beneficiaries are, and they can utilize both income and principal, yet still have that trust fully protected from all creditors, divorcing spouses, lawsuits, bankruptcy, Medicaid, and even estate taxes. So when we create a trust, a revocable living trust or irrevocable trust, upon death, that trust doesn't end, it divides. And in this case, it divides here into 3 beneficiary controlled trusts. And this is full asset protection. The cost of these trusts relative to the potency of them is de minimis, and is a great way to leave the next generation much more secure than you could have left them if you left it outright and they then tried to do planning. Once a child inherits those assets from you, they can't do this type of trust. They cannot protect assets for themselves. And we'll talk about what you need to do to protect assets for yourself in just a moment, but it is not close to what we call third-party trust planning can provide for the beneficiaries. Okay, so we've talked about the core four: the power of attorney, the healthcare proxy, disposition of remains, and a will. And your plan would have all of those. If you layer on a revocable living trust, that's the fifth document. And that is a very, very comprehensive and complete plan. I just want to talk very briefly about the current and future federal estate tax. And most of you probably have heard of the sunsetting of the Trump tax laws, which is going to happen, if nothing else happens, next December 31st. So January 1 of 2026, we may have an extension of the Trump tax cuts. We may not. It depends upon what comes through Congress. Right now, most people are thinking he'll get his tax cut and it will last for a while, subject to those budget constraints, the debt, the deficit, and we'll see how that all plays out. The estate tax right now is $13.61 million, the exemption for federal gift and estate tax, $13,610,000. On January 1 of next year, that goes up to 13.99 million. Let's call it 14 million. So every individual can gift or die with $14 million and have no federal estate tax levied against their estate. If the sunset does occur, that $14 million will get cut in half to roughly $7 million. So for high net worth individuals, they have been doing the planning and will continue to do the planning to take advantage of this enhanced estate tax exemption, the $14 million exemption. And there are a lot of different types of trusts that we use to put in place a plan that can lock that down. Many more people are subject to the New York State estate tax, which comes in this year at $6,940,000. If you get up close to that amount, there are a few things that you need to be aware of. One, in order to get marital planning in place, you have to do a trust so that you can actually double that exemption, and you don't want to go over the 6.94. If you do go over the 6.94, New York has a punitive law. Makes absolutely no sense. But if you get 5% over the 6.94 million, which means if you have an estate of $7,287,000, you are 105% of the New York State exemption, and your entire exemption goes away. You lose it. So at 6.94 million, you pay zero estate tax. At $7,287,000, you pay roughly $650,000 of estate tax. We call it the cliff. You have to be aware of it if your estate gets up into these ranges. New York does not have any gift tax, and there are a lot of ways that we can plan around the cliff. I'm not going to go into a lot of that. I have put in your slides some of the income tax provisions, and this is the TCJA, the Tax Cuts and Jobs Act, which is destined to go out of existence on December 31st of next year, unless extended. We do think that it will be extended to some degree and in some respects. These are some of the things that are relevant: child tax credits, alternative minimum tax, and there are additional proposals that were not part of the original TCJA that are supported by the current president, including the elimination of liability for taxes on Social Security, tips and gratuities, overtime pay. So again, reality check on the federal debt and deficit, the interest payments on the debt. We'll see how many of these things can be brought in and how many can be gotten through the Senate and the House in legislation. Okay, so we have about 25 minutes left. And in that time, I want to cover Medicaid asset protection trusts, and I'm going to just touch on some of the other spousal lifetime access trusts and a really particular use of a charitable remainder trust. Gifting is part of planning. We can gift to individuals. Right now, there is something in place called the annual exclusion, and that is you can gift $18,000 per person per year to anyone, and that is a tax-free gift. Remember that you can also gift $13,610,000 in addition to the $18,000 per person per year and pay zero gift tax. There's no federal gift tax on that amount, and there is no New York State gift tax at all. Should you make outright gifts in large amounts? Should you gift your house to your children? Should you gift other assets directly to your children? The how and the why are the two key questions. Why would you be gifting large amounts today? Is it for tax planning? There are trusts that we can use that are much, much more effective than outright gifts. Or is it for asset protection planning? And there are ways that you can structure the asset protection plan much more effectively that are not outright gifts. And when we talk about this, remember a Swiss Army knife. The solution set very often involves different types of trusts. So when we're creating trusts, not just for probate avoidance, the revocable trust takes care of that, but when we're creating trusts for asset protection or tax planning, we're going to tailor those trusts substantively to accomplish these goals, maintaining as much control as we can over the trust assets, maintaining access to the trust assets in many cases, yet still having them outside of our estates for tax purposes in certain types of trusts, and for Medicaid purposes in what we're going to talk about and focus on next. So when we look at these safeguarded trusts, what is the number one risk that most people face today? Our healthcare system, thank goodness we have Columbia Memorial Hospital and the foundation supporting expansion and new services and things that Barbara can tell you about. But when we get to payment for long-term care, when we need home health care, help with our activities of daily living, if we ever need a nursing home, if we need assisted living, we want to make sure that we have a plan in place that gives us all of the options that we can muster up and have at our disposal. The cost of long-term care today is approaching, and in some cases exceeding, $200,000 a year. And if you want to spend $15,000, $16,000, $17,000 a month, that's going to take your state down very, very rapidly. So we're going to talk a little bit about how to plan for long-term care and what that need is, how it works, and what you can do now to plan and protect yourself for the future. When long-term care is needed, almost all of our clients, and if I did a poll right now, and we're not going to do a poll, but if I said, where would you prefer to be taken care of if you have a chronic condition that requires assistance with those activities of daily living, I would venture to say 99.9% of you would give the answer, I want to be in my own home. I want to age in place and stay in my home with my dog, with my comfy chair, with my own kitchen, my refrigerator, the comfortable things that I have in my life. I want to be in my home and have care brought in. That care can be as expensive, if not more expensive, than a nursing home. When you look at, you're spending $35 to $40 an hour now to hire a private home health agency. And if you do the math of 24-hour day care times $35 an hour times 365 days in the year, you're up around $260,000 per year for 24/7 home health care. So when we look at this, where do you want to live? Almost always in the most independent setting possible. Maybe you want to go to one of the nice independent living centers where you can have an apartment or a townhouse and you can have services and a chef and a gym and trips. Those are wonderful places to age and live and great communities. And very often they're tied together with the next levels of care, assisted living and nursing home care. That's an option. But you have to plan for that. And you have to be prepared because it's not inexpensive. And you have to be able to and willing to sell your home typically to do that kind of planning. For those people that want to live at home and hunker down in their own home, who is going to provide the care to you? And this is really the hardest question to answer today. It's the hardest puzzle piece, is where do you find caregivers who will come into the home and provide that care? And then the $200,000 question, how do you pay for it? And there are only three payment sources when we get to this level of care. It's you. You're going to pay for it out of your bank account, savings account, IRA, investment account, reverse mortgage against your home. Whatever resources you have, you would be compelled to draw down and use to pay for care. If you're foresighted enough to have a long-term care insurance policy, and only about 6% of all people in the state of New York have long-term care insurance, 94% do not, then you may have a policy that's going to help defray the cost of long-term care, and you can be able to stay in the more independent setting and be able to thrive where you want to be. If you don't have enough money between what you have in income and assets, and you don't have an insurance policy, or it's not sufficient to pay $16,000 or $17,000 a month, then the only program that does pay for long-term care is Medicaid. Many people are deceived or don't think hard enough about this, and they think that Medicare is going to cover unfortunately named programs, both enacted in 1965. Medicare is an entitlement that everyone gets at age 65, and it covers things like hospitals in Part A, physicians in Part B, drug programs in Part D, and they have Medicare Advantage plans now in Part C. So 4 different parts to Medicare. You get it at 65. What Medicare does not cover is long-term care, the home health care, assisted living, nursing home care that you may need if you suffer a chronic illness and need help with those activities of daily living. So we have to get Medicare and disabuse ourselves of Medicare being a solution in this realm. And let's talk for a minute about realities. And one of the realities is that Medicaid becomes the lifeline for most families when they need chronic care. And Medicaid has 2 main parts. One is chronic care Medicaid, or nursing home Medicaid is another way to say it. And if you need care in a nursing home, then you're allowed to keep a certain amount of assets and a very small amount of income, $50 per month. And Medicaid will come in and pay for your long-term care in a nursing home. There is a 5-year look-back period. So if you try to give assets away, we'll talk about the eligibility level in just one moment, you're going to have to account for 5 years. And within that 5-year time period, if assets have been transferred, you will be ineligible for Medicaid for a period of time. Flip that over to where you really want to be, which is in the home. And to qualify for Medicaid home health care, we have similar asset rules, but we don't have any transfer rules yet for home care. And I say yet because the government has passed in New York State a 2.5-year or 30-month look back for Medicaid home care. So you have to get out in front of the home care by at least 2.5 years. Those rules have not yet been implemented. We've been told by the New York State Department of Health sometime in 2025 to anticipate the implementation, but we have not heard anything definitive on when the Medicaid home care penalty rules will go into play. So here is the reality of Medicaid. You need to spend down basically in assets, and let's start on the asset side, to about $31,175. So whatever assets you have, bank accounts, brokerage accounts, etc., $31,175 is going to be the limit. If you're in a nursing home, your home becomes part of that countable asset base. If you have an IRA, 401k, other retirement plan, and you are collecting on it, That is the one major exempt asset for Medicaid purposes. You can have an IRA or 401k. You have to draw down on it from an income perspective. The income counts, but you can exempt an asset. $500,000 million IRA is an exempt asset if you are drawing on it and taking a periodic payment. The one major exception to the rules. If we're at home, we can keep $1,751 of income. And what happens if you go over $1,751 of income? This is for an individual. In New York State, we are able to use something called a pooled income trust. So you can divert excess income into a pooled income trust and keep your income available to pay your other expenses. The question becomes, if we need to get down to Medicaid eligibility levels for assets, how do we do that? And let's go back to our Swiss Army knife and pull out the next blade. And the next blade is a Medicaid Asset Protection Trust. This is an irrevocable trust, has to be for Medicaid purposes. It's a trust that we are not the trustee of. We have someone else be the trustee, and they're going to manage it. In many cases, it's children. In other cases, it's siblings or other third parties, but not the grantor of the trust. The grantor, the client, can keep income for life, the right to use property for life. It has very good tax benefits in terms of the home, real property exemptions, star exemptions, veterans exemptions. You can sell your home and keep your capital gains tax exemption on the sale of a home. So when we construct plans for clients, many cases it comes down to an analysis of, okay, I don't want to be in probate. I don't want to drag my family through the court. I don't want to have to go through that, have them go through that delay, the cost, all of the things that could happen and go wrong in a probate proceeding. I want to avoid probate. Great. I want to have my assets managed for me during my lifetime in a trust where I can set the rules and write the script. Great. Then we come down to a revocable living trust, which is going to give us all of those advantages, or an irrevocable trust called the Medicaid Asset Protection Trust, which gives us those same things, but adds the layer of asset protection so that whatever I put into this trust, my home, my stocks, my bonds, my money, my assets, whatever I put into this trust is protected and not countable for Medicaid purposes. And if you feel comfortable that you have enough income and insurance and all of the things buttoned up on the side of long-term care, then a revocable trust does everything you need it to do. If you think that at some point in the future you may need Medicaid to defray the costs of long-term care, whether it be home health care or nursing home care, then you want to consider the irrevocable trust, which we call the Medicaid Asset Protection Trust. And the three biggest differences right here on this screen. Number one, I'm not the trustee. I have someone else as trustee during my lifetime to manage this trust for me. And I'll tell you how we make that a little bit sweeter and a pill that you can swallow. You keep the income from the assets. You keep the right to use the home and the other assets. The heirs are remaindermen, which is usually our children and grandchildren in most cases, are going to get this while the trust, when the trust ends. And remember, we can have our beneficiary control trust created then. We transfer in our home, bank accounts, stocks, bonds, annuities, life insurance, businesses, real estate. I can keep the income, but it's irrevocable. I'm not the trustee, and I cannot get the principal directly. Directly is the key, because on the back door of the trustee can give principal to third parties, my beneficiaries, which again could be my children, could be siblings, could be nieces, nephews. When those people get money from the trust, there's no restriction on what they do with it, and the principal can then be used back for my benefit. So gifting out of the trust is one way that we can get money to specific beneficiaries who could then actually use it back for my benefit. So I said earlier that 401ks and IRAs and other retirement plans don't go into the trust. The good news is they don't have to go into the trust because for Medicaid purposes, they're exempt. So in an overall plan where we want to layer in asset protection on top of our trust plan, we're keeping a certain amount of cash, bank account, savings, checking in our name. We're going to keep the IRAs, 401ks in our name. We're going to put the home and the other assets listed here into the trust. And how am I feeling about doing that when I'm not the trustee and I don't have the right to get principal? We want to put certain strings in the trust. One is I can change trustee at any time. So even though the trust is irrevocable, I have control over who's running it. So if the person I name as trustee is not managing properly, I can change that and name a new trustee. If the people I name as beneficiaries are not behaving properly, I can change that. I can remove them as beneficiaries and change beneficiary. So those two levers, the lever of changing trustee, the lever of changing beneficiary, keep control for us over the trust. And that gives us the ability to have a trust that is effective for both probate avoidance and asset protection, in addition to lifetime management. Under New York law, there's an even better provision that says if I get consent of my beneficiaries, who I can name at any time, I can actually revoke the irrevocable trust. So as we walk through the process with clients and we put pen to paper and we put your assets and your family situation down, we typically draw a diagram laying out the different trust options. And it's from there that you can make an informed decision as to what's comfortable for you. What is the right plan for you? Remember, for the asset protection side of this, you have to be out 5 years. And we have the 2.5-year look back period that we're waiting for word from the New York State Department of Health on as to whether that is going to be imposed at this point in time. Peace of mind is important, knowing that when you put your head on your pillow, you've got everything in place. You've got the right people in place. If you get sick, you've got healthcare decision makers, people that can pay bills on your behalf, secure your finances. You have a trust that's going to manage assets for you. And if you have a long-term illness, you have the ability to access Medicaid if and when that becomes necessary, while at the same time, in a well-designed plan and trust, keeping access to all of those assets and income that you have at your disposal. So legacy is an important part of that. And one of the things that I'm going to close on is that the legacy portion of a plan that has IRAs and 401ks became much more difficult due to this law. And this passed back in 2019, went into effect in 2020. It's called the Secure Act. And what the Secure Act brought us was a 10-year payout rule for beneficiaries of IRAs, 401ks, and other qualified plans. Under the old rules, if you inherited an IRA, you could do something called a stretch. You could stretch that IRA out over your lifetime. Remember that all of these accounts, other than a Roth account, is fully income taxable. So if I have a $100,000 IRA and I leave it to my son, he's going to pay 100% income tax on that IRA. Under the old rules, that can be stretched out over a lifetime. Under the new rules, it has to be exhausted over 10 years. There are certain exceptions to this. You can name a spouse, and you can do a spousal rollover. You can name a disabled child. Disabled child is an exception beneficiary, an exception eligible designated beneficiary, or EDB, and they can actually stretch it again over their life expectancy. If you leave it to someone who's chronically ill or a trust for someone who's chronically ill, they can stretch it over their life expectancy, or someone who's less than 10 years younger than you, or more than 10 years younger than you, I'm sorry. So a 10-year spread or more, you can, or less, you can leave it to that person, and they will also be eligible for the stretch. The 10-year rule, if you have large assets, and an IRA, 401k assets, And when clients come into us, very often they have a two-tiered balance sheet. They have retirement accounts, they have real estate. And those are the main assets that they have to deal with. And if you are leaving these large IRA assets to children, grandchildren, know that they're going to have a lot of income tax consequences on those retirement plan assets. So when we look at capital and we look at our investment capital inside of retirement accounts, we have choices. We can leave a certain amount to our beneficiaries, and that's the part that you keep and you leave as legacy, or we can pay tax, and that's the part that you can't keep. Is there a way that we can avoid the tax part, keep more of the assets, and still have benefits flowing to others? And this is where we get into charitable planning and charitable planning for IRAs, which we'll close with. One thing that's a very powerful tool, if you want to make gifts to charities now, you can withdraw and leave directly from your retirement account to a charity like the Columbia Memorial Hospital Foundation, up to $100,000 from your IRA without paying any income tax and without it even being considered adjusted gross income. So it stays completely off of your income tax return, which has savings in other ways across the board, including state income tax. So you have no AGI from a $100,000 donation directly from your IRA to a charity. Next year, that number goes to $105,000. So for clients that are giving annually and you're over 70 and a half, the best way to give is to give direct gifts from your retirement account to the charity. Another tax leveraged gift to charity is highly appreciated securities. If I bought NVIDIA at 8 and now it's worth 80 or 180 or 280, I have a significant capital gain. But if I donate that NVIDIA to Columbia Memorial Hospital Foundation, they pay zero gains tax. And I get a full deduction for the full value of the stock contribution. So tax leveraging gifts is a great way to give and receive. The tax benefits from charitable contributions, whether it's from an IRA or using highly appreciated securities, are substantial. Upon death, what we do with clients very often is they'll come in and they'll say, well, I want to leave CMH $100,000 in my will or my trust, better yet, my trust. And we say, okay, so you have the assets in your trust, they're highly appreciated securities, and then you have an IRA, and you're going to leave $100,000 to the charity, and you're going to leave it from the highly appreciated securities that get a full step up in basis. So that's like cash, and then you're going to leave the IRA to your kids, and they pay tax and have to draw it down over 10 years. So simply by rewiring the plan and saying, I'm leaving everything in my trust to my children because they get it dollar for dollar. And they don't pay any tax on it because it got a stepped up basis for capital gains tax purposes. There's no capital gains tax. I'm going to leave the retirement account to a charity which pays no tax because it's tax exempt. And they get 100 cents on the dollar from my retirement account. So simply by crossing and taking the charity and leaving the retirement assets to the charity, the trust assets to the individuals, you save significant amount of tax dollars, and that dollar looks a lot better when it's divvied up. The next one is a little bit more complicated, and this gets into charitable giving and philanthropy. We do a considerable amount of that in the form of charitable trusts, and there is a particular type of charitable trust that we've used to reinvigorate the stretch. So you know that an individual beneficiary is capped at 10 years to take it out. But you can use a charitable trust, and depending upon the age of the beneficiary, you can either have a lifetime income or a 20-year income, and the IRA gets payable to this trust. The trust pays no income tax. The money gets reinvested inside the trust. The beneficiary, your child, grandchild, receives an income stream that you define and maximize over that 20-year period or their lifetime. There's an actuarial calculation that's done at that point. And then after that term expires and your beneficiary has reaped the benefits of that enhanced value producing income for them over a 20-year minimum term, then the money goes to the charity. So that is a charitable remainder trust, something that has become, again, very much in vogue due to the higher interest rates in effect right now, and something that we're using more and more frequently with our clients. So how do you get started? How do you get your plan in place? Get a fact finder. We do a online questionnaire that we would send to you, and that gives us all of your personal information, your financial information. It is very secure. We can send you the encryption details, but it's a way that we can get a head start on the meeting, and we then offer a free consultation, as many estate planning firms do. We'll sit down with you, draw you the flow charts with your own information, and let you then make the decision. What plan is right for me? Do I want a basic will plan, the core 4? Do I want to layer in a revocable trust? Do I want to layer in some asset protection and perhaps a Medicaid asset protection trust? Those are decisions personal to you based upon your own information, but do the homework. Do the work, get the information in before the consultation, wherever you go, whoever you see, because that will allow you to have a much more detailed and in-depth conversation about your own personal situation. This is our firm. We have offices in Latham. That's our main office, New York City. And I also maintain office hours in Hudson at 541 Warren Street. And I'd be happy to meet with any of you there. And you can contact Barbara at bcmh.net.org. And for us, you can just email us at info@pierolaw.com or give us a call at 518-459-2100. Be happy to talk to any of you about your own personal estate planning.